Okay. Good afternoon, everyone. The Directorate General of Taxpayer Services, Mumbai, welcomes all the officers and participants today for the webinar on the topic Impact of GST in Intellectual Property Rights. First and foremost, I'd like to inform the participants that our principal ADG sir, Sanjay Rathi sir, has recently been promoted as the Chief Commissioner and has been posted to Visakhapatnam CGST zone. While we congratulate and are happy for him, unfortunately, he will not be able to attend this meeting because he's taking charge there. So, in his place, our additional commissioner, Shri Arvind Kumar Singh, will be delivering the welcome address. Sir, I request you to please address the participants.
Thank you, Joseph. So, good afternoon, everyone. And as you all know that Principal ADG is now Chief Commissioner Vizag, and he is, due to some emergency, he could not deliver this welcome address. So, on behalf of DGTS Mumbai and on behalf of him, I am going to read out his speech only, whatever he has written. So, it is his speech which I am reading out, that's all. I stand privileged and honored to extend a warm welcome to this webinar. I intensely appreciate the support and cooperation extended by Confederation of Indian Industry (CII) and All India Federation of Tax Practitioners. These associations have played a vital role in accelerating the growth of industries and services in India, accelerated genuine grievances at appropriate level, enabling the government to address and redress the problem in right perspective. The role of these associations is in stimulating, shaping, and scaling up Indian economy is undisputable. So here, I would like to welcome Sri A.S. Besla, Senior Advisor, Indirect Taxes, CII, and Sri Mukul Gupta, Chairman, GST Representation Committee, All India Federation of Tax Practitioners, AIFTP. So, as you all know, that DGTS Mumbai Zonal Unit is regularly organizing the webinars on different various topics, and it can happen with your support only. And today's topic is impact of GST in intellectual property right, IPR, and the speaker today is Sri Kodandaram, Assistant Commissioner retired, CBIC. He is master trainer of GST for CBIC, and Nasim. He has trained thousands of officers on taxation and related laws. He has wide knowledge of topic. This session will certainly be fruitful and will aid in improving the duty compliance. So with this, I'll hand it over to you, Joseph. Please go ahead. Over to you, Joseph.
Thank you, sir. Thank you for the encouraging words. Now I take this opportunity to introduce today's trade panelists, Shri A.S. Bisla, who is a Senior Advisor in Direct Taxes at the Confederation of Indian Industry, and Shri Mukul Gupta, who is Chairman, GST Representation Committee, All India Federation of Tax Practitioners. Our first panelist, Shri A.S. Bisla, is a Senior Advisor of the Indirect Taxes, CII. He has more than 32 years of practical experience and exposure to the tax administration in customs, central excise, and service tax, covering manufacturing, services, import, export, drawback, and other export incentives and litigations. At present, Shri Bisla is providing his services to CII as a senior advisor for indirect taxation. He also disseminates, collates, and deliberates on the issues and suggestions of industry on indirect taxes and GST for submitting recommendations to the government for consideration. He also provided clarifications, advocacy, and had done hand-holding of the industry during transition and implementation of GST. He's also qualified by NASIN, which is an Apex Training Institute of CBIC, as accredited trainer for GST. Our second panelist for today, who is Shri Mukul Gupta, who is also the chairman GST Representation Committee of AIFTP. is a senior partner and strategic advisor for GST, and in Sharnam Legal is a law graduate and also holds a bachelor's degree in statistics. He has been practicing since 1980 as a tax consultant in the field of indirect taxes and corporate governance. Mr. Gupta is a member of the board of directors and chairman audit committee of large listed companies. He is also a member of the Supreme Court Bar Association, New Delhi, since 1985, as well as a member of the International Bar Association and founder member of Association of Tax Lawyers. He is the off counsel with Mrs. Titus and Company Advocates, New Delhi, where he has extensively advised Fortune 500 corporations in structuring their operations in India from the standpoint of indirect taxes. He has presented technical paper legal risk management for financial institutions, as well as chaired on working session on corporate governance in the International Conference of Jurists on Rule of Law. Looks like we have a very learned and distinguished panelist today. Now I request Shri A.S. Bisla to address the participants.
Thank you, sir. First of all, I would like to congratulate Chief Commissioner Sri Sanjay Rathi ji on his promotion and assuming the next charge. Distinguished Additional Commissioner Arvind Kumar Singh ji, Director General Sri Joseph Goda Patil ji, former Assistant Commissioner Sri M.J. Karan Dharam ji, and my co-panelist Advocate Mukul Gupta ji, Chairman is GST Representation Committee FTP, officers and industry participants. Interactive sessions with CBIC officers give an opportunity to stakeholders to get deeper knowledge on the topic and understand the nuances of the provisions. Interaction also brings officers closer to the stakeholders, where officials also get new ideas, issues and suggestions, which paves the way for further improvements, remove bottlenecks, and to add EODB. Thus, it is win-win for both. DGTS, particularly through its interactive webinars, is doing a tremendous and most sought-after services of hand-holding stakeholders by making them aware of the changes introduced from time to time in customs and GST, and explaining and sharing the government's views on various provisions. Industry and stakeholders get immensely benefited through these interactions, get their queries resolved, and also get deeper understanding of the provisions without routing through the consultants and litigations, thereby saving their time and money both. In the series of such interactions, today's webinar is on a very important topic. Maybe it is less traveled, but many businesses may have doubts and face the issue. As rightly pointed out, IPR consists of patents, trademarks, and copyrights, and are subjected to GST. While the introduction of GST in India has brought several benefits to the taxation of intellectual property rights, still there are certain challenges and issues that stakeholders need to address. The taxability of copyrights under GST depends upon the nature of the transaction. IPR transaction under GST can sometimes be ambiguous. For instance, distinguishing between goods and services. Specifically, in the digital and technology sector can be very complex, leading to classification disputes. Some IPR transactions might have both goods and services components, creating challenges in determining the nature of composite supply or tax rates. There may also be challenges in valuation for determining the taxable value for IPR, especially for transactions involving royalties, licensing fees, and lump sum payments. After transfer pricing, issues can arise for multinational companies, complicating the valuation of cross-border IPR transactions and leading to disputes. Further, determining the input tax credit on expenses relating to IPR can be very complex, such as expenses may have mixed use nature comprising exempted and taxable, or use may be across different states. Further, I would like to mention that the requirement for the reverse charge mechanism on the import of IPR services can be cumbersome for businesses who are not regular importers, and particularly small and medium enterprises, due to additional compliance and cash flow issues. Export of IPR services is zero rated. The proper documentation and compliance to claim refunds of input tax credits needs to be monitored very closely. Businesses with IPR transactions spanning multiple taxes, multiple states may face complexities in dealing with interstate supply rules and compliances. As the GST is evolving, frequent updates and changes, it requires constant vigil from businesses to remain well compliant. Increased tax liabilities or compliance costs can impact the overall business strategy and pricing model. Therefore, GST implications on IPR related costs needs to be carefully managed. Contracts also needs to be adjusted to GST provisions, particularly in long-term licensing and assignment agreements. While GST has streamlined the tax structure for IPR in India, several issues persist and require careful management and strategically planning. Today, we hope so that officers shall navigate through complexities in classification, valuation, cross-border transactions, and compliance issues, along with deliberations on beneficial parts of input tax credit and zero rate for the exports. Therefore, today's session is very important for the stakeholders to get the deeper understanding on the related GST provisions and clear their doubts, or may ask straightaway questions on their apprehensions and issues. I would request them to put their queries in one go rather than putting in piecemeal, and the queries also should be related to related to today's topic only. So it will be better for the officers also to give straightaway answers to the queries. So again, on behalf of CII and its members, I thank senior CBIC officials, particularly to the DG team, for their valuable initiative, for the interaction and presentation which will be made right now, and for associating with CII in this August presentation today. Hope that stakeholders shall get benefited with the deliberations to be made by the well-conversant officers. Thank you, and over to you, sir. Thank you, sir.
Thank you, Bislaji, for your words. Now I request our second trade panelist, Shri Mukul Gupta, to address the participants.
Thank you very much. First of all, I would like to extend from my own side as well as from the side of All India Federation of Tax Practitioners to this Director General of Taxpayer Services, Mumbai, who has thought of deliberating on such an important topic of impact of GST on intellectual property. It is really a fantastic topic and needs much deliberations. And I hope today's speaker, the retired Assistant Commissioner, would enlighten us all, and many of the queries of our members would be solved after hearing him. I would also like to extend my heartful good wishes to on the promotion of our DG Saab as a principal commissioner, and he's taking a charge on this auspicious day. So my heartfelt thanks for providing me also this opportunity to him. I would not take much of your time. I would just like to mention that the area of intellectual property in the indirect tax is a new area. Only after 2017, when GST was implemented, this new area has given much broader base to tax the transactions on this important right or goods or services, whatever they are, because a lot of light is necessary as to what they are. Even though the government of India have already given much clarifications, GST Council have also deliberated on various aspects of this important sector. But still, I believe, as my previous speaker have also mentioned, still many doubts are there. So, to my mind, that earlier in the pre-GST regime, the temporary transfer of intellectual property rights were not at all touched. And now it is also taxable from 1st July 2017. One of the important problems or important issue which I think is that there is no definition of intellectual property rights under the GST law, which gives an ample room for interpretation at the very beginning. The SSCs are also a dilemma, because we represent our members in the AIFTP represent SSCs from all over the country. I receive various issues, various problems from them, that what stand they can take, because any wrong stand taken now by the SSC will be very, very detrimental in this indirect tax system of GST. So that should be brought, because there are definitions available in a circular which was an earlier circular of 2004. But many officers, when we represent before them, they say that they don't follow the meaning, because they are not bound to follow that. They go beyond that. So what stand the SSC should take is a big problem. The next issue which I think is a big problem is the transfer of copyright and the goods or services which entail that copyright. Many people do not distinguish them. So they say that no, we have already paid tax on the goods which are covered by this copyright, so the copyright is also taken care of. So, which is not the correct view. So, this needs to be taught to the SSCs so that they should not do wrong in this aspect. The two are very different from each other. They have to be separately dealt with while they are planning to transfer the rights, either temporary rights or permanent rights, whether along with the goods or along with the services, or even along with the digital things. So that is another big issue to my mind. Then also there is a dilemma about the assignment and licensing, because this issue of intellectual property is very much based on this. A large quantum of revenue is coming from either from the assignment or licensing. The SSCs again are not able to distinguish between them, even though the rate of tax is same, but how it is to be dealt with is different. The provisions of law, one is service, one is goods. So they are needed to be dealt differently when it comes to various questions. And I also would like to touch about this packaged trademark and packaged things. That is also creating little detrimental from the point of view of the consumers. So that is also to be seen how actually this would be more productive in overall usefulness of GST on giving this exemption, because I have read in many newspapers that some large entities are also using this opportunity by unbranding them or not packing them with the brand products. So that is also to be looked into. And lastly, I would like to just touch upon the in the earlier regime, franchisee fees was covering the trademark, copyright, patent, and other proprietary rights also. So there is a confusion here also in this regime that since we are paying the franchisee fees, which covers everything, so there is no need of paying separately or distinguishing separately, or the separate valuation if there is there in the agreement. So they do not take into consideration that that separate valuation for these transfer of rights. So these are some of my observations, and I believe we will get the answers from our learned speaker today. Since the time allotted to me was just few minutes, so I think let the seminar progress further. Thank you very much. Thank you for the opportunity.
Thank you, Shri Gupta ji. We are very happy that you have raised some very pertinent issues and points that will be discussed in the session. And we thank you very much for your participation. Now, I introduce our speaker for today's webinar, Shri M.G. Kodandaram, Assistant Commissioner, Retired CBIC. Shri Kodandaram is a master trainer of GST for CBIC. He has trained thousands of officers on taxation and related laws, as our ADC sir was mentioned in the inaugural address. He is also a member of the State GST Committee, Federation of Karnataka Chamber of Commerce and Industry, and an advisor of Karnataka State Council for Science and Technology. That is a very interesting kind of a profile for a single person. He holds a bachelor's degree in science and an LLB, and PG diplomas in several fields from business administration, IPR law, cyber law, and cyber forensics, mostly from prestigious institutions like the NLSIU. He is also the author of books titled GST at a Glance, Concept, Law and Procedure, GST Classification, A Practical Guide to GST Practitioners Examination, and GST Law, A Ready Reckoner, all published by the Karnataka Law Journal publications. It's pertinent to note that he was felicitated by our former Union Finance Minister, late Shri Arun Jaitley, during the celebration of Foundation Day of NASIN, and as the outstanding faculty of NASIN for his contribution in the field of training and capacity building. Also from our former chairman, Shri Vivek Johri, CBIC, our former chairman, Vivek Johri, released the book titled GST Law Ready Reckoner, which was authored by our speaker today. So his contributions run into many pages. So this is just a small snippet that I thought is worthwhile to mention in this forum. So with that, I now request Shri Kodandaram ji to please begin his presentation.
Good afternoon to everyone. I'm very, very happy that I have been given an opportunity to speak on IPR when connected into GST. This very recently in Bangalore Nation, I spoke for nearly 2 days for 4 sessions. Now I will try to deal it in 1 hour. So there will be a lot of gaps. We will have one more session if required on import export, as our Ajmer Bisla sir was telling, and especially on trademarks itself. We can have a separate session, but we will today try to take everybody together so that there is a common understanding. My talk will be in the initial stage. First 5 minutes I'll speak something about intellectual property and whether it is one definition is possible or not. It is simply impossible, but it has been done in the customs side enforcement rules 2007. When you see we have border enforcement rules coming from TRIPS article 50 to 60, in that we have right holder, but that kind of thing will be very difficult to handle each of the separate IPR, and there may be, it is difficult, number one. Secondly, the way I am trying to guide you is whatever transactions happens, what are the facts of the case, you must be able to realize and apply the law. To that level, you can understand and make your own control over the IPR transactions at each place. Let me start my talk by sharing my PPT. Is my PPT visible to all of you, sir?
Yes.
Yeah. First of all, we should know what is an intellectual property. Intellectual property is a virtual property. Any product, to get value, there is need of material as well as the mental ability to upgrade that. Then we should recognize both the intellectual activity as well as the material intellectual activity applied to the material. So virtual property, though IPRs are, they cannot exist on their own. They have to be expressed in a tangible item. So that's the one basic thing we should know. There are rights given. What is a property? Property is nothing but bundle of rights. This is my house because under registration, it is my name is written. Under the law of the land, the rights have been given to me. Similarly, for the intellectual output, expression, originality, it is recognized, and if somebody wants to use it, they should seek your permission after applying. That power is given to you by vesting that right in you. And that's what is, in brief, we can say intellectual property. It's an intangible, owned, and legally protected. It's a legal right. It's a legal negative right. Why? I will let you know. By a company from outside use and implementation, here individual also is eligible. So my talk will be what is IPR. We'll spend some time, not more, because it's very difficult for me to go through the further part of it. And types of IPR, in one slide we will try to know, and others I have given details there which you can apply. Now, whether it is a supply, we will look into those aspects in detail. What are the stages during granting, during licensing, during assigning, when it is expressed in goods, when it is expressed in services. Some aspects of imports and exports also I have covered, because each of them are huge and each one of them has its own challenges, which we will deal some other time for transborder movement of goods and services involving IPR transactions, especially in customs imports of goods. There is a lot of issues need to be looked into. With this, let me move. It is nothing but property created by the intellect of the human mind that is being recognized. If you do not recognize the intellectual ability, then there is no motivation for the creator to do so. You take the recent example of our COVID vaccine. If we don't recognize the work of the intellectuals behind the scene to create this vaccination, it would have been impossible for us. Within a short time, they have invested crores of rupees money, and they have done a lot of laboratory tests. They have done spent crores of rupees to come out with a product. That knowledge has to be recognized. Sir, what is the benefit to the public? That's the question everybody lost. You will give him the right of that invention, no doubt. But what is the public is going to get? So public is going to get is full disclosure of that invention. Means if anybody invents or does something and he fully discloses it, once he discloses it, then that will be provided as his right if he is eligible for a limited period. Because if you allow them to be using forever, it will be impossible. It will be a result in monopoly. So therefore, it's a legal right, intangible potential asset without leading to monopoly, where we have a limited duration that is being provided as an intellectual property for that person. Sir, what is the use in the public? We cannot inventing the same thing again and again. We need to progress in the society. There is need of development in the society. So what has happened in the past should be known. If you look into the earlier era and the IP era, earlier undisclosed knowledge has been lost to the society because of this non-recognition of intellectual ability. So therefore, in the commercial area today, where civilization has led to a commercialization, development, economic, things like that, it is very much necessary to recognize these rights and implement them as prescribed under the law. So these are all legal rights subjected to the national law in place, being eligible the applicant when he makes it. So it's a negative rate, but for a limited time. Is it a movable property or a immovable property? Because if it is an immovable property, it will go out of GST, as you know. It is a movable property only because it can be shared, it can be marketed, it can be assigned, the title also can be sold, but it is not a tangible property. So therefore, it is a movable property. In certain situations, it may become a immovable property. For example, if there is a name given to a service dealing with immovable properties, there, once that immovable property things comes into existence, there may be some problem, but it is very rare. Let us not get into that. Let us look into the bulk of the issues we will see. Sir, is it a property? People do ask me. What is a property? As you know, it must be possible for me to hand over my title. Then it is a goods. If I don't want to hand over the title, no doubt I can give other rights other than the title. So when I give any other right like possession or utility, whatever name you want to call for a limited place or a limited approach, we call it as a service. That is, those two words in the IP regime are called assigning and licensing. If I sell my house, it is called assigning. If I rent it out, it is called licensing. If it is a house, it would have been an immovable property, but here it is a goods. And there, when I sell the title of that, there it becomes a goods transaction. So to some extent, I hope I have reached each one of you to get into this common base. You are able to possess it, own it, because under the law, you are granted that license, permit. So accompanied with an interest, because nobody can do anything except your. Sir, is it a property as per the Constitution? As you know, Constitution is the basis. Yes, Article 300A speaks of property. It doesn't differentiate intellectual or otherwise, and therefore it is a property, but it is not a fundamental right. In the beginning of our Constitution, it was a fundamental right. Now it is other rights, common rights. In the pre-GST period, there is always a dispute, as my friend was telling, senior friend. So there, that is slightly reduced in the GST era. I don't say it is totally eliminated, but today I will not go into those problem areas. Let us try to understand the main course. Then some of the time we will take it as a challenge there. See, in the service tax, what happened? A permanent transfer of IPR is goods, and therefore you cannot levy service tax. In the VAT, they were collecting because it is goods movement, and that's also disputed. Let us forget the past for the time being. But in the GST era, I have given you what is that. IP owners are expanding the usage of their properties by way of giving license or assignment. If it is assignment, it is supply of goods. If it is license, supply of services. Sir, if that licensing or assigning, how it should be understood? What are the different types of transactions? For that, I will go a bit further to say how an IP is generated and how IP is owned and how IP is commercialized. So three phases I'm trying to devise there. IP generation by the creator. The second part, IP, once he generates, how he uses it, whether he himself uses it or with somebody else, how he transforms, whether he licenses or assigns. Once he licenses or assigns, how it is commercialized. So these three aspects are totally different. Not only IPs are different, but also the types of transactions in one IP goes from one phase to another phase to phase. So there is complications of multitude that chips in. Patent Act, it is given for an inventor. It may be a product or a process. Wherever there is novelty, utility, non-obviousness, only that much I could tell you now. We popularly call it as none, not N-O-N-E, N-U-N. Where he is the first fellow to invent, up to 20 years from the date of filing, patent is recognized. Means anybody who wants to utilize his invention, his vaccine, has to take his permission and he can license them or he can assign them and tell you can do whatever you want. So there, the creator, let us say Mr. A, approaches the patent office, applies, works for that patent, obtains that application being cleared, then he gets the right, property right. That is the first part. Once he gets the property, once he becomes the owner of that property, then he may alone deal it, or normally nobody can alone deal it because world over they want to spread out. So they may license it, or if it is an individual, he may assign it to the company itself. You do whatever you want. You give me this much money, you hold the title. So depending upon the nature of the creation, he will do that. Then once the new licensee comes into place or new assigner comes into place, how he deals, expresses in his goods, or he is in turn further can license or otherwise, these are all the intricacies we need to look in. Similarly, copyrights. Copyrights are a bit more complicated than patents. Here in complicated here because the nature of copyright itself, it may be a literary work. Here literary work doesn't mean it should be a novel, things like that. Literary work, anything reduced to writing, even your computer programming is also called a literary work. And therefore, it is slightly different. And what is protected, unlike invention, here is copy. Nobody can copy. For example, if there is this idea, that idea can be expressed by many in different ways. Each of them is a separate copyrighted one. So expressions are alone protected, not the idea. So similarly, if it is an artistic work, musical work, dramatic works, sound recordings, films, each of them, variety of things are there, and the application of time limitations are also different. When you look into designs, industrial designs means a product gets sold. जो दिखता है, वही बिकता है. So the very look of a product can also be registered. If somebody has created a new product, new design, he can register it and it is valid for 15 years. So there he can get the rights. Its own shapes, configurations, patterns. Similarly, trademark, which is distinctive and non-descriptive, which will provide goodwill, reputation. Then trademark used as a brand name, and brand name along with further franchising. So trademark is the initial recognition given by the office government. That trademark is used in a brand of a product. So trademark gets converted into brand due to commercialization and a unique way of expressing the trademark. And from there on, it is also due to goodwill developed in the market may lead to a franchisee method of working. And thereby, all the three are also to be looked into. Today, I will deal less on trademarks. We will limit our talk because both copyright and trademark itself is a huge aspect to be learned. Geographical indications, not much of an importance, except we want to protect our Indian soil, the geographical knowledge, the traditional knowledge which has come from generation is being recognized for that area, for the people of that area, the association, that they are the owners of that product and they can alone market, like our Darjeeling tea or Mysore silk saree or Mumbai's mangoes. That is very famous. I am forgetting Alfonso mangoes. All these are also here. Unlike other trademarks, GI is not an individual mark. It's a mark for the group. There is a part A, part B, where part B people can take part A and do their work. These are all in brief I'm trying to give you. Now, most important is I'll just switch on to my sheet here. Here we should know the types of transactions. Then it is easier for everybody to understand. Let us take Mr. A. He may be an individual. He may be a company employee, or it may be a team. They make an invention, then they will apply for patent. If they make a program, computer programming, then they will apply for copyright. If they make a design of a product, design here, outward look, then they will go approach design office. If they make a trademarked item, trademark, that trademark office they will visit. GI, I will leave it now. So these are being scrutinized. So there is an application by this applicant and the government department, concerned department will take it for sanctioning it. There is huge amount of money that has to be spent, starting from filing fee, plus up to the grant, and there may be a lot of oppositions, there may be adjudications, all other administrative aspects also take place, for which the IP office handles. IP office is a Government of India office, and there is a taxability on this because what they give is the rights, property rights, the virtual rights in the form of a certificate to the concerned applicant if he is eligible, or they may reject. Both is possible, but there is a transaction going on here which has to be subjected to tax. That is number one part. Now, we will move to the second part. Mr. A, who is already possessing the right, we can call it him as right holder. Now, this right is in itself doesn't help. For example, if I have a vaccination formula, that itself is not. It has to be commercialized. For that commercialization, they may have a facility or may not have a facility, whatever may be. We will assume this has to be expressed or put into tangible items. Then only the product that comes out will be in the marketable. Here he may do it, or he may hand it over to Mr. C to do that task, where he may license it, where C is obligated to give him a royalty regularly. Or if it doesn't want, let us say, a new owner he may create and assign it. Come on, you give me so many crores in one shot. You do whatever you want. I don't want your headache, whether you are able to commercialize or otherwise. Here, this is an assignment where title is also transferred. This is the second transaction that may take place. The third transaction is Mr. C. I think I gave C only. I am becoming old. No, C correct. C or Mr. O, how they do? Here, this C, when he makes goods, it is expressed as a part of the goods value. Here, what should be the classification? Because here IP loses its identity. IP is applied to the goods. IP is applied to the services. Here, the commercial aspects of this goods value is already includes this because he has already got licensed and he has paid the license and he can utilize that GST paid also here. And in the goods, he need to include this as the cost, and whatever his goods sales are there are said to be inclusive of this IP. So there is no need to look into IP angle provided he doesn't charge separately. That's very important. There may be a huge machinery there, even if it is a goods, that person may say technology charge separately. At the time, we have to capture that and take tax on that aspect also. So this is the third stage possible. As my reverend friend was telling, on imports and exports, it's further complicated. We will try to deliberate it as much as possible on imports and exports. I'll try to give you, to the best of my ability, the easier way of understanding. This is what I have written. Kindly go through this. Now you'll be able to understand. At the time of grant is the stage 1. At the time of licensing and assignment is the stage 2. The all others are 3. I hope I have been very, very clear with you. Okay. Now, application process in RP office, what they do, the registration, licensing, search, examination, publication, then he becomes the right holder. From there on, this journey has 3 different phases, and in each phase, there may be alterations. And especially in the copyright, there is one more stage that comes in, where there is a common right holder in the form of certain agency being created under the copyright law. That also I am going to deliberate. Is it a supply? I think I can spend less time on this, not more time, because it's like any other supply. It is a supply. There shall be levied, you know, the section 9(1). Scope of supply, yes, whether it is transfer, sale, barter, all that is we have included. But look into the schedule T2. Activities or transactions to be treated as supply of goods or supply of services. We have made temporary transfer or permitting the use or enjoyment of any IPR. In other words, whether it's goods or services, we are trying to reduce and make all of them as services. People may not agree with me. I also do not subscribe for it, but that is what the GST law has tried to make. So temporary transfer, permitting the use of IPR, they have said permitting the use could be assignment. Permitting the use or enjoyment of any IPR, because the word sale is never used in the IP legislations. So therefore, this could be that luckily the rate of tax is same, so we don't have to worry much. Sir, how do you say goods are separate? You can see here, any chapter, permanent transfer of IP rights, 18% we have made. Then what is the necessity of this? So there is some confusion in the people who wanted to legislate, that people may say it may be goods. So for that, as a escape route, even this is provided. If not there, I'll catch you here. So that's the analogy I feel. Don't feel bad. And secondly, look into the 11/2017 notification, which talks about different rates, which was existing for quite a long time, and then it was changed, where temporary or permanent transfer or permitting the use of enjoyment of IP in respect of goods other than information technology, in respect of information technology software. So information technology is a copyrighted item. There is a problem of classification there also. You might have heard of Tata consultancy case, where if it is in the CD to be treated as goods and customs duty to be paid, if it is something downloaded online, it is a service. So with the code number, then it is still goods. That problem still arises. But now, because all of them are made into 12%, we can breathe a sigh of relief. But in the initial stage, still there is a problem. There's need to look into the section 8 also now, because this could be the IP generated rights vested in an individual or a person or a company could be used for goods as well as services. When it is goods or services, whether the section 8 comes into picture, the answer is yes. It is a composite supply. Therefore, when it is a composite supply, we need to treat them as goods if it is on goods, if it is on services as services only, or if it is in respect of immovable property, it has to go out of this. So there is some confusion. We will keep it aside for some other day's discussions. Then you go to the section schedule 7, the consideration aspect. Section 7, if you see the import of services, now we will look into the import aspect. Import of services for a consideration, whether or not in the course of furtherance of business, no need of business test. So if there is import of service by a person from a related person, no need of consideration, but still it is a supply. So there is clear understanding that even importation of a intellectual property by a relative for without any consideration is still taxable under GST. So that's what I have written here. Since it is categorized as an import of service by a person from a related person without consideration in the course of business, it is to be treated as service. Now, we will try to cut short the rate of tax applicable. Don't have to look at the upper part, come to the column where I have told you IP grant stage on fee 18%. Assignment, it was 12%. Now it has become 18%. So licensing was 12% because other than IT products, information technology products, now it has become 18%. So goods and services as per the applicable rates of respective goods and services. Transfer of information technology is 18% and 18%. So this is how we need to look in. Now we will go to stage 1. Kindly get back. In stage 1, these are all the officers for each of the rights you have to apply. All of them are government department, Government of India. These are all national laws and the rights given are applicable within the nation. They don't have international recognition. However, like PCT arrangement is there, where they can file international patents. Similarly, mandate agreements provides for the concerned thing to be filed together, and making a well-known trademark can be recognized all over the world. So there are international agreements expanding this national rights into international rights, and normally this regime is recognized. But still, national, international fights go on, that we keep apart. So in this government office, it should be, I am the inventor, I can go directly, or I can hire a patent agent, or a copyright expert, or an IP attorney, or whatever profession you call. I can hire them and they can do my work. Fine. So there in stage 1, the person application may be an individual entity or this one. And what are the other words? It may involve search, examination, litigations, adjudications, all of them are involved there. So then it leads to registration grant and continued renewal free. It could be professionals assisting, you call whatever name you want. Each this whole country has its different names. So there you can call them as advisors, trademark associates, or advisors, brand promoters, patents, IP agents, franchisee promoters, whatever you want to name. Now for me, now things are, what is the tax availability here? What is the GST applicability? GST applicability starts here in the generating state. Today, as on today, it is not properly covered by all of us. All the stakeholders need to look into this part. The second part and the third part are more or less covered because it becomes a commercial one. Here it is with the dealing with the government department. Here one more exemption is, if somebody applies and the fees charge is more than 5,000, then the government department also need to collect taxes on that individual. You can look in here, I have given the concerned notifications. Are all services provided by government or local authority exempted? No, all services provided by the government or local authority are not exempted. If it is covering in 4, any service other than the services 1 to 3 above provided to a business entity are not exempt. So to a business entity, if IP department gives a service, it is not covered. But if it is a government department, it has to be under reverse charge mechanism. The department need not file, but the party seeking it should pay. So in that event also, there are 2 more notifications to be looked into. Sir, what will be the revenue? Here are some revenues I have given. I am not able to segregate them. It is not possible. This is what their annual report says. So there may be little scope for looking into revenue implications here. Are government local authority liable to pay tax? Yes, the service recipient are required to pay the tax under reverse charge mechanism. This is what the implication of this. Then up to 5,000 rupees, if it is an individual, it is exempted. If it is a company, again, up to 20 lakhs or 10 lakhs, as per the common this one, exemptions are available in the concerned notifications. So that's the notifications I have given. So what will be the result of it? It is a bit complicated. I request you to spend patiently with me. IP, I am an individual. I am directly applying. If my fee paid is more than 5,000 rupees, the IP department is expected to collect GST from me and deposit, register. If that is not to an individual, but to a businessman, I will call it as registered GST registered individual or a company when it applies. If its turnover is less than 20 lakhs, there is no GST. There, they need not collect GST. So there they have a complication. On an individual who is not registered, if it is more than 5,000, they have to collect. Not otherwise. Here, if it is 20 lakhs or 10 lakhs, depending upon the state, there is no GST. But if it is beyond that, then there is a GST. But if when I go through a consultant, so there, consultant into department and the applicant and the consultant. So consultant gets his money also, and therefore the consultant's team, when it goes to the government department, this is what applies. He is eligible for 20 lakhs, he can get it. But here, when he charges his invoice to the party, here it has to be paid under reverse charge mechanism. Here also in reverse charge mechanism, kindly note. So there, the party should include all his gross collections from the party, from the concerned applicant. So if there is an advocacy fee or whatever name he calls, all his expenditure, such fee, all that he need to spend. And this is what the law is telling. I'm trying to express what law says. And I have given the flow chart so that it is easier for you to follow. I will move to the second stage. Second stage is where the person who has owned the IP uses it allows it to be commercialized by others, to be applied to the services and goods. Means Mr. A gives a certificate, a license to Mr. B, Mr. C. So when he gives, he has to collect licensing fee. On that, he has to pay 18%, or if he assigns it at 18%. So there, 18% will be the second stage. So 2-3 is at the second stage. This is not that difficult, but here you should be very, very clear that the transaction is only giving the license. If it is something beyond that, like franchisee, brand and all, there the deviations will occur. There we may have to capture more money other than the license fee he takes. So we should be very careful how each contract is entered into for utilizing his rights by somebody else. Now that Mr. somebody else who takes that and applies on his products, applies for his services, that's the third stage. At that time, the goods or services are sold, which will be inclusive of cost of the license he has paid. There may be an agreement where this licensee fee could be as per the number of products that are being manufactured. At that time, the licensing fee at stage 2 also may go on increasing. We need to capture that also. Or if it is simple licensing for a particular period, not depending on the number of output, at that time it is much easier. So we have to look into those contractual things. And at this stage, there is, if it is included in the first part itself, then whatever the GST rate of the particular goods are there, that will be applied. If it is exempted, a particular trademarked good, then the stage trademark used there gets exempted, but up to the point of his license, that amount becomes cost to them, and therefore there is no escape of taxation also. But here section 8 comes into picture, and therefore when we take it as a composite supply, in the third stage, we need to stick on to the composite supply law and look in it is a supply of service or goods, and there accordingly we need to take the decision. Now that software, I think I can skip Tata Consultancy, I have referred already. Now, what are the classifications? I always say there is an aberration in the classification of GST. There is need to do classification of goods is fine because it has spent nearly 40-50 years time it has been spent. One WTO GATT agreement, I think it is in the 1950s, 60s, they have ventured there. And from there on, it has come, and now also there are a lot of issues there. But in the case of services, we have tried to do a short work, and we have not been very clear because it's from a common product service code available in the UN directories. From there, they have picked up and tried to make it exclusively services, that in a short time, and there a lot of confusion still arises. But these are all the classifications of the various services possible. You can look in this. I have listed out. Kindly look in, and the rate of tax is same, so less the problem to some extent. Then in the copyright, now we will move to copyright. In copyright, there's some issues to be known. If it is a literary work, the owner is the author. Then if it is a dramatic work, then author. If it is a music, composer. Artistic work, artist. Photograph, photographer. Cinematography, producer of the film. Computer programs, person who caused the work. They will own the rights. In 2012, they came out with an amendment in respect of literary work, where they said if somebody has created a literature and if it becomes a music, everybody at every stage is eligible for the share of the profit. So that's another problem. We will not discuss that problem here now for the time being. So copyright infringement happens, making infringing copies for sale or hire, permitting any place for performance, distributing without public exhibition, importation, infringing. These are all varieties of things. Registration of copyright is not a must. Only when you want to have it as a legal right and to establish that you are the first writer or the author, then only it is required. It is an automatic one which is recognized under the law. However, certificate will help you. So this is certain basic aspects of copyright regime. Now, here, this itself was a problematic one. Now we have come to our reverse charge mechanism. In the reverse charge mechanism, we have further split into two. One is dramatic, musical and artistic works, where music composer, photographer, artist or the like, and the recipient of the services will be music company, producer or the like. They will pay tax on behalf of it. Original literary work is not covered here. Sir, what is original literary work? What is dramatic work, musical work, artistic works? Don't go by the literal meaning of it. Original literary work has been explained expansively in the copyright law. You have to apply for all. I told you it includes even computer program, even dramatic, musical. So there, don't take it from the common man's understanding. You need to look into the concerned section 13 and the various definitions. In the earliest talk, when I had a lot of time, each one I explained that and how each one can be playing this role I have explained. Now for the time being, we will understand only that much. The second part is very, very important, where original literary work from the author. If the author is a registered person, if he says that I am paying the tax, then there is no need for the publisher to pay. Otherwise, publisher shall pay. When transborder movements are there, this will create much more problem. Today, we will not go into copyright issues with the transborder because it may not be prima facie available issues as on today. But the last one here, any services supplied by any person who is located in non-taxable territory, that is outside India, to any person other than a non-taxable online recipient, it will be covered here under reverse charge mechanism. We will look into some more examples. Before that, we have said stage 1, 2, 3. Here in stage 3, there is another agency that has been created. They are called registered copyright societies. Sir, I have written a book, I have a copyright, but I cannot enforce the copyright. Sir, I have made a music, I cannot commercialize the music because I do not know who will show when and all. I can't keep track of it. In other words, if there is an infringer, I will not be able to take action. And the amount and cost involved is huge and I will not be able to bear for it. And therefore, I assign it or hand it over to a company who is also recognized under the law. Not that it is somebody association separately. It is also recognized under the law. They are called registered copyright societies. A copyright society is a collective administrative society. And they administer and they are under the control of Government of India. Of course, prior to 2012 amendment in the copyright law, there was some issues of certain agencies. Now they have set it right. So there, the common, all the rights of the individuals is given there and they charge differently. What are the various societies available? For example, IPRL, it's the oldest, IPRS is the oldest one. For musical works, literary music within India, people can go and register there, hand over their rights to them. They will manage their enforcement, commercialization, things like that. You have Indian reprographic rights, IRRO, for issuance on behalf of the authors. Then you have Signfill, Society of Producers and Other Rights. Music Performance, RMPL. You have Indian Singers Rights Association. So these are all associations where they give a common service. These people also have to be licensed. If you look in the variety of licenses they give, I tried to do some work in respect of some societies. I'll just try to show you one or two, because where variety is the requirement here, you can see, for example, this is about Indian performing art, amusement parks, for tariff for amusement parks. This association has separate rates. Depending upon the area, only background music somebody uses, whatever may be the music of their company's total 1 lakh they have to pay. So this 1 lakh gets distributed to those owners. That itself is a very tough ask after their expenditure is over. Similarly, this is about 25 acres. This is on scope of tariff, music performance of music amusement parks by mechanical or electronic devices, including radio, CD players and all when they use. These are all the conditions, background. Here, luckily they have registered and they have indicated that the tax payable is at 18%. You look into television satellite broadcasting. For that, they have a separate one. Means each one is a separate way of handling things. So there, further complications are there. Our people who are all stakeholders and the professionals who are handling taxation and the people who are in the industry, kindly look in. What is possible here is, what is the consideration for what it is given? Both should be considered, evaluated, tax part should be taken. That is the only way left, depending upon each contract. That's what I understand here. Okay. So I've tried to give, see, for internet, for Karoko service, for each service it is different. Nobody can do. If you do audit of this, it requires a huge amount of time for the officials also. And for them, unless they computerize also, they may not be able to distribute their profits. How they are doing itself is a big issue that needs to be looked into. So for pubs and disco, they may charge more. So these are all certain varieties we need to look in. I'll move further. Then we will look into imports and exports a bit. Import of IP services. As I have already told you, if it is from a related person, import of services by a taxable person from a related person or from any of his establishments outside India in the course or furtherance of business, even without a consideration, becomes a taxable event to be paid under reverse charge mechanism. IP services. IP in goods is itself a tough ask, but we will try to give only some relief in that, not much possible. So IP services. Will import of service without consideration be taxable? Yes, if it is from a relative. That's what we can say, because it is also a service, import of service. The second question, how will import be valued? Sir, I am getting a goods where there is royalty I am paying for those goods. How you are going to evaluate? When you are evaluating a goods, you have to use the import valuation of customs. Now, when goods are imported, they are subjected to GST as per Section 5 proviso in the IGST Act. So Section 5 proviso, 5.1 proviso talks about it. 5.1 proviso says it should be as per the Section 40 Customs Tariff Act, as per customs valuation law. There you need to look into customs charging section of Section 12 and Section 14 of the Customs Act, and you have to read to the Customs Tariff Act, Section 3.7 and 3.9. 3.7 for GST, 3.7, 3.9 for composition levy if it is there, compensation cess if it is there. So these two I need to look in and then arrive. If it is a service, there is no scope for customs. There we need to go for general practices. This is also reiterated in our CGST rules 34. Kindly look at here. Here in 34, of the taxable goods shall be applicable rate exchange as notified by the board. So if it is goods, we need to go to Section 14 and the notifications issued regularly. That should be the transaction value, value of foreign exchange I need to take. And further, whether that service is prior to import or later to import, or the contents made out of these goods when it is exported, how it is to be, if it is treated favorably or otherwise. All these elements need to be looked into in respect of goods, so also in respect of services. But in respect of services, valuation will not be on the customs law procedures, but in respect of goods, prior to import, if it is incurred, then it will be as per Customs Act. Place of supply is always the recipient's place of supply shall be the location of the recipient of service. If the nature of service falls under 33 to 1330 IGST, then if hence IGST is to be discharged under reverse charge when recipient is in India, RCM will be applicable. Whether a transfer of title or possession is necessary for a transaction to constitute a supply of goods, title as well as possession have to be transferred. Then only it is goods, otherwise it is a service. If you look into another FAQ, transfer of right to use goods shall be treated as supply of service because there is no transfer of title in such supplies. Right to use goods still is treated as a supply of services. So there is, as I told you earlier, the GST legislative groups of the GST Council need to look into this aspect. Then import of services, two more important things is pertaining to intermediary services. There, especially in the IT/ITES sector, if you look into question number 11, I am an Indian company who makes software and sell it outside the country. I have a firm C located abroad giving me the services of supply of software in Europe and USA. I am billing them, but he is helping me to supply it in Europe and USA. I am paying him some money. Whether I have to pay GST on that, it has been clearly said, no, he is an intermediary. In intermediary, the supplier is outside India. He doesn't have to. But if you look into question number 13, I am an agent in India for a coffee company, whether you are liable to pay, the answer is yes, because place of supplier is in India, and therefore whether it is in India or outside, you need to get discharged under GST. So these are all the issues, some of the issues. And to put it, I am coming to the end, don't be this one because I have taken more time than what is normally called in the DGTS meetings. Let me get into this. Exports, it should be part of the value if it is already covered or if it is billed separately, and they have to be treated as zero rated, provided on the input aspects of that IP credit has been availed. If it is credit is not available or licensing is not available, then he might have not be able to get relief there. So we need to look into the entire aspects where exports are concerned. Similarly, the value of the goods should include all these IP things because IPs are expressed in those tangible items. So when IP in itself, no doubt it's a right, it's a bundle of right, but it's a bundle of negative right. Only when it gets converted into commercial activity, it should have goods or a particular kind of services with serving goods also there. So those kind of things need to be looked into, and because of peculiar nature of the IPR, these issues do come. But there are certain related reverse charge mechanisms possible, like advocacy services, arbitral tribunal services, sponsorship services, exchange of IPRs, during mergers, acquiring, valuation of IPs, transfer pricing, transborder. I can keep on talking. So this is what is all about. I'm very happy. All India Federation of Taxpayers, they have published my article, IP and GST, a comprehensive analysis for the Indian enterprises, which is published in May, June 2024. I thank them. There I have tried to very simple so that everybody can get into. If more pages are given to me, we can come out with a detailed talk on this aspect. Revenue implications are huge, and therefore we need to look in. Let us try to recollect, friends, to the best of my ability within the limited time available. I have spoken what is an IPR, what is a supply, whether it is supply, during granting, licensing, what are the facts of each issue when it becomes a goods or a service, we need to look at, especially in the trans-border situations. It's each contract will play a role. With this, I come to the end of my talk and I open up the forum for question answer sessions. Please. I will stop presentations. Now you can ask me questions if it is available in the chat box. Please. I will look into the chat box because I did not get any response. In the chat box, there
is one question, sir.
Yeah. Can you read them, sir?
Yes.
One by one, so that there is some order.
Mr. Kodandra, can you see? There is only actually one question.
There's one question.
Sir, a taxpayer having IPR created various dummy firms.
Yes.
The very word dummy firms, this is where our preventive group may look in. Okay. I don't think I deserve any answer now in this forum where only honest taxpayers are sitting. Right? Let me not get into those things. Right? I will be able to answer this if there is a question asked separately, one-to-one. Okay.
Thank you, sir. May I ask a few questions on your presentation?
Sir.
That specific points need some more elaboration or clarification.
Yes.
Like one point is that you have narrated that if the application for registration of any rights is filed through some consultant, so then under reverse charge, there will be GST liability. So in that case, sir, there are two scenarios. Suppose that consultant's threshold limit is already crossed, means his turnover is more, but he files the application on my behalf. So in that matter, he charges his nominal fees, say 20,000 rupees for the entire process, and he pays the fees of the government on my behalf in my name. So everything is in my name. So in that case, will he not be working as pure agent? And then should not all these two transactions be treated separately instead of paying GST on the entire amount under the reverse charge mechanism?
Yeah.
Why may be within the threshold limit? So this is the first question.
Yeah, I think I will answer this, sir, instead of going to second question. It will help me also. Let me answer this and I'll take your second question later. Please. So now first question, I'll try to answer him. Yes, I appreciate his approach. Fine. It is, let us say, A is an applicant. He may go through a professional, and professional on behalf of him will apply to the government. Here, as you are saying, the government amount should be under reverse charge mechanism. This person is liable to pay. But when he charges this, it is not like the normally when we have seen, they will charge as a wholesome money. So there is a transaction between A to P. There is a supply, and P on behalf of him, he does. Wherever taxes are paid by him on behalf of the party, if he has paid in the party's name, then this can be called as pure service, what you are saying. Yes, I do not deny it. But over and above, the gross amount should be taken. This amount should be allowed. Then the rest should be charged by him. In the second transaction, it is not reverse charge mechanism. He will take it as a forward charge person. I hope I have answered you, sir, a bit.
Sir, I think it is like a customs broker. They charge
right,
importers, and they show separately that way.
Yeah.
And they don't charge again GST on the portion of the customs duty paid or any other fees paid to the government.
Yes.
That is shown separately as pure revenue.
Yes.
Sir, my next question is, you have mentioned that there are associations who take up the matter on behalf of an individual artist or like that, and then they allow the users on charging fees. Suppose say they charge 1 lakh rupees fees from the user for that allowing of any performance of that right, or maybe even allowing that play of the music. So in that case, association will be paying or raising bill to that user of 1 lakh rupees and then paying GST on that.
Yes.
Am I right, sir? To this
Right.
extent?
You are right.
Sir, second is part comes when, because this association is like a club, and GST considers any association of persons will be treated as a business entity. So when they will be distributing that amount to individual members, whether their threshold may be less, because suppose I had composed that music, my turnover may be very less. I may be a very poor singer or poor musician like that. So still he gives me only 10,000 rupees. So there are 10 members. So they will distribute 10,000 rupees to each member. So here they are earning 1 lakh rupees on my compositions and just giving me 10,000. And that too, they are charging GST on my that 10,000 rupees. So is it the right approach, or is it the procedure, or there can be some deviation in this procedure?
So procedure wise, as on today, as of law, it is chargeable. But when they charge to an individual, pay them 10,000, if that eligible, that person, individuals, this one is less than 20 lakhs, he can still claim the benefit of the service. That's all. Other than that, as you say, it becomes a dual.
I'm the composer. So my turnover may be less. So I am getting.
You will get up to 20 lakhs to your whatever amount you have received from him, and similarly from others. Entire thing, if your all India turnover is less than that, you will enjoy. Otherwise, you have to pay. Similar issues are there in respect of, I think recently, this mutual fund agents, they had approached me. There also this issue is there. If they are registered with GST, mutual fund department will not deduct. Otherwise, the person, that department will deduct that money. Similar situation may arise here, but still it is not settled down. As I'm telling you, those industries are now, as of now, appears to have registered because they have said you have to pay 18%. We are collecting all the clear notifications they have given to the users of their commercialization. But their activity, how they are distributing to the creators, is not available for me. If that is made available, if I can visit any of such industries, then I think I'll be able to better. But now, as of now, as per law, this is what we can tell them. If the person who creates, if it is turnover is less than 20 lakhs or 10 lakhs, depending upon the place of this one, registration of him, we can allow, not otherwise.
Sir, you have rightly.
It's a double levy. It may become a kind of a levy which gets segregated to each one of them. Yes, distributed.
You have very rightly equated it with the distribution of dividend through mutual fund or like that also. Because here also, because I am an artist, I don't know whether I have to raise the bill to the association or not. It is the association only which will distribute at the end of the month or any period.
Yes.
So it is like distribution of the dividend, you can say. So it is totally uncertain about the amount as well as the tax portion. Thank you, sir. Sir, next question I will take it, sir. Valuation on import of, like say, copyrights for services. So if it is import of services, I am holding one session in Delhi, and my known person is in sitting in abroad. He has composed something, and he has got it copyright patents over there on this his creation. But since he is known to me, he says, okay, you can organize one concert in Delhi. I will provide it online free of that music or to play or like that, sir. Sir, because customs is not coming in between for this valuation. It is like ODIR or it will be under again IPR, and how the valuation will be done. I am importing it for business purposes, but I am not paying anything to him. And he may be my related person, he may not be my related person. So how to you see solve this puzzle?
What the law says, it is taxable. That's all I can say.
Taxable. Point is valuation.
Valuation aspects, I think if you give me the nitty-gritties, this has to be depending upon whether he will allow you to be used as goods or a service. It is a service. So whatever transactions, outflow of revenue is there.
He is allowing me to use its service, that too for business purposes, because I am holding a big event. I will be earning crores of rupees even in that event, and I am ready to pay the tax on it.
Yeah.
On what value?
On what consideration you have paid him? What is the foreign exchange?
No, I have not paid, sir. I have not
then
paid.
It has to be generally agreed upon. If such event were to be held in India, what is the rate he is having, whether he is having any rate thing available. Otherwise, we have to go for cost plus. It is as per the GST law, section 15, with rules you have to apply. Their cost plus method we may have to adopt.
For these creations, I don't feel so that cost is any way factor.
Yeah.
Because if I have composed a song that is very good for dancing, so it is composed 2 years back and it is being played throughout the world. So now you can't say what is the cost for assigning it to me only.
Right.
That's true. It is for business purposes without consideration. So how value can be arrived? And I am ready to pay.
No, value can be arrived at because everything can be valued. But there are 3 different methods of valuation. If there is similar product available in the market, take that. Here it may be not possible. Or it is kind of a cost involved as a price. That could be the method. There are 3 different methods in the AS standards still available. You can adopt and come to some price, but you cannot say that is the value. There it is open for interpretation also, sir.
So that is why I said it is a matter of dispute, because the music cannot be compared with any other music.
Yes, you're right. You're right. That is the issue, especially in the intellectual property rights. Valuation even today is a big issue. Valuation of IP products. It may be, for example, a trademark of certain company may be at the top, but once the company becomes a fraud company, the brand may go off. And what happened to the loans given? They fly away. So those things do happen. It's an intangible assets. It's a virtual asset, and therefore valuation has its own challenges. We can come at certain values which is acceptable. Not that it is impossible, but need to go to AS standards, and as per that, we have to arrive at. It is possible.
Thank you, sir.
Thank you. At this age, you have shown so much of enthusiasm. I'm really very, very happy, very proud of you because you have understood the nitty-gritties. One appreciation is that you have gone through my talk in depth at this age. Thank you, sir.
Thank you, sir. Thank you. It is my you see, privilege to join today's webinar, sir.
Any other doubts? Upal Gupta, sir, I think yours organization has published. Yesterday it came. I thought of putting it so that the concerned people are getting some this one information. They can go through that magazine and they will get all these informations there also. This PPT I am going to share. Kindly use it. If there is a complication, my email is there. There you can send the query. If it is commercial interest is there, I will charge it through my invoice also. Okay. Sorry. Sir, if there are no questions, we can complete our session today, sir.
Yeah. Okay. Thank you, Shri M.G. Kodandaramji, for the elaborate and excellent presentation. I also think it was beneficial that you have actually taken the FAQs. Maybe that's another reason why, otherwise, usually we have a lot of doubts in these sessions, but maybe because you've actually handled all the FAQs, so there was not too many. I really thank you for throwing light on the intricacies and the impact of GST on IPR. As we come to the end of the session, I would like to request Shri Sanjay Kumar, Assistant Director, DGTS, Mumbai, to extend the vote of thanks.
Sir, good afternoon, everyone. On behalf of DGTS Mumbai Zonal Unit, I express my sincere gratitude to Sri Sanjay Rathi sir, Principal ADG DGTS Mumbai Zonal Unit, who has now been promoted as Chief Commissioner, for his guidance and support. I also extend my sincere thanks to our Additional Director, Arvind Kumar Singh sir, providing his valuable guidance in organizing this dinner. DGTS Mumbai Zonal Unit extends its heartfelt thanks to both our trade panelists, Sri Mukul Gupta ji, Chairman, GST Presentation Committee, AIFTP, that is All India Federation of Tax Practitioners, and Sri A.S. Bisla ji, Senior Advisor in Direct Taxes, CII, that is Confederation of Indian Industry. Thank you, sir, for giving your valuable time and presenting your viewpoints on the topic. And last but not least, I express my special thanks to our speaker, Sri M.G. Kodandaramji, Assistant Commissioner, retired, for his excellent and insightful presentation. Sir, it was a thorough and elaborate presentation, and I'm sure the trade must have benefited by the knowledge shared by. And now, with the kind permission of our Additional Director, sir, I would like to bring this session to an end. Thank you all.
Thank you. Sarve Janaha Sukhino Bhavantu.
Thank you, sir.
Thank you.
Thank you very much.
As I'm listening you. Thank you. Thank you.
पहले संजय सबको मिलना संजय बाबा को